think we should both.
It's recording.
That's good. I think we should both keep our mics on.
Yeah, that sounds good.
So we can kind of naturally pop in and out if need be. I guess we could turn our videos off if we wanted. Or just stay here.
You can just stay here.
Yeah, why not?
It's lovely seeing your face.
It's lovely seeing your face. See, we're letting all the people as they come in know how good friends we are. And that's going to set the tone for the whole thing. It's happening right now. They're wondering, did they mean to keep this conversation going? Yeah. I hear you, Dr. Robertson.
All right, well, welcome everybody again to another University of New Mexico Law and Mental Health Didactic Series. This is hosted by the UNM Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're glad to have so many people here with us again. I'm Anthony Perillo, the Forensic Psychology Training Director here in the Department of Psychiatry and Behavioral Sciences at the University of New Mexico. Through this talk today, if you have any questions, you will enter them in the Q&A box in your screen, not the chat box, but the Q&A box. We will reserve those questions until the end of the talk. We try to get to as many as possible, but it usually is not possible for us to get through all of them. So just bear with us there. For those of you that want continuing education credits, you do have to stay for the hour, but you do not have to stay longer than the hour, even when the questions go over that hour. I'll try to let you know when the hour is passed, even if we stay longer for those questions. For those of you that are pursuing medical education credits, there will be a sign-in sheet in the chat box shortly, and that is the process that you will go through. For those that want APA continuing education credits, around the last 5 minutes or so, you will see a link that's posted in the chat. You'll want to open that before you leave because you won't have access to it after this. And you'll want to make sure that when you complete that survey, that you save the certificate. We don't get access to those certificates. There will be a recording and PowerPoint slides for this talk available in a week. And at that point next week, we will have Dr. Michelle Guyton discussing multiple relationship issues in forensic work. But that's next week. This week, I'd like to introduce you to our co-presenters here, the speakers that you've been waiting for, who will be presenting on evaluating youth transfer to adult court. We have Dr. Jason Lawrence and Dr. Molly Persky. Jason Lawrence is currently employed at the Center for Behavioral Medicine in Kansas City, Missouri, as a forensic evaluator for the state of Missouri. He conducts private practice evaluations related to juvenile waiver, transfer certification, mitigation, competency to proceed. He obtained his doctoral degree in clinical psychology from Sam Houston State University. He also chairs the Access Path Award for the American Psychology Law Society, supporting promising students from historically marginalized or excluded backgrounds connect with research experience and support that they need to boost their competitiveness for grad school for the next generation of forensic scholars. Molly Persky, she completed her doctoral degree in clinical psychology from Pacific University. After that, she completed a forensic psychology fellowship at the Center of Behavioral Medicine's Department of Forensic Services in Kansas City, Missouri. She conducted criminal responsibility, competency, and SVP evaluations in that role. And after licensure in Oregon, Molly's worked in private practice where she conducts a variety of psycholegal and forensic evaluations. She has extensive experience providing expert testimony, supervising pre- and postdoc graduate students, and conducting research on a lot of different psycholegal topics. Her most recent article focusing on criminal responsibility evaluations was published in the Journal of Forensic Psychology, Research and Practice. Jason and Molly, on behalf of the University of New Mexico, can I just say we're very excited to have both of you joining our series. We're thankful for you willing to share your expertise and coming at this from different states and different perspectives. I will now throw it over to you.
All right, well, thank you, Anthony. Really appreciate it. Appreciate the invite. Those who don't know, Anthony Perillo also chaired that Access Path program. That's actually how we met each other. But yeah, we're really excited to be here. You know, this is a really fun webinar and CEs that are available for everybody. You know, you've had some great speakers in the past, Dan Murray, Tess Neal, and now you have us. So congratulations. Yeah, again, I'm Jason Lawrence. We also have Molly Persky, and we're going to be talking about evaluations for juvenile transfer to adult court. See, we're already having problems. All right, so Anthony already went over our bios, so we won't really re-go over this, but I guess just so you all know, Molly and myself were actually both postdocs at the Center for Behavioral Medicine together. And we sort of ended up getting into the work of juvenile transfer certification, waiver, depending on what state you're in, evaluations around the same time in totally separate manners, which is kind of interesting. And so when I was invited to give a talk on this, I reached out to her to do it with me and give us all different opinions and views from different states about how these evaluations are done. Because Molly, you've been doing these for a couple of years now, right?
Mm-hmm.
Yeah. Good. So you're gonna get some good perspectives from how things have been going in Missouri regarding this, at minimum, interesting legal question. You'll hear a lot of us complaining about how vague a lot of this stuff is. I'm also gonna do my best to not swear, but I like to curse a lot. But a lot of this stuff is, and yeah, we're going to try to keep it really sort of practical in terms of the things we personally have experienced, and hopefully you all find it pretty useful. So here's something about CEs, don't worry about it. Here's something about disclosures, just trust us. Here's a disclaimer that we don't represent UNM. All right, here we go. So to start us off, our learning objectives today, we want to give you a bit of history on the actual juvenile transfer statutes and requirements, kind of like where this came from, how it came up. We will not be spending a lot of time on this. If there's anyone out there who's like a legal historian, you're going to be really upset at us. But we're really just hitting like some highlights that kind of directly influence sort of the work that gets done today. But of course, it's a long history. It's all quite complicated. We're then going to talk about, both myself and Molly, our different approaches to the juvenile transfer evaluations, the different situations that we do these evaluations in, and then the standardized measures that both of us use or don't use and can or cannot be applied to these types of evaluations. So we want to start with things that are good to know, which is that history of the juvenile court in general, along with some relevant case law. And then we'll get to the stuff that I like to call things you really need to know to kind of do the work. Because as you'll hear, as we discuss sort of our professional journeys, there's only so much kind of like formal training when it comes to these types of evaluations. There are things available in different states. Lawyers have different ideas of like what they expect, what they want to see, judges do. It's kind of all over the place. There's lots of good resources. And so we're sort of hoping this will be a good sort of jumping off point so that you can have an idea of at least what it looks like practically in some circumstances. And that can let you sort of gauge what you want to explore maybe in your own state. Because there's a lot of need for this type of work, I think, in every state, it's probably fair to say. All right, I'll throw it over to Molly.
So we're going to use different names when we talk about this, but they're interchangeable. But generally, when we talk about juvenile transfer or waiver or certification, we're talking about evaluations that are done to determine whether a juvenile should be tried as an adult or should remain in the juvenile system. There are also what's called reverse waivers or reverse transfers, where basically a juvenile who has been waived to adult court is now attempting to go back to the juvenile system. And we're not going to spend time talking about reverse waivers, but I think it's important to note that the criteria that's considered in reverse waivers is the same that's considered in normal waiver to adult court. So we wanted to spend some time talking about the history of the juvenile system. I think it's important to discuss because I think it provides some context or rationale behind the decision to even try juveniles as adults. So pre-1899, there's really no specific juvenile legal system in the United States. And then in 1899, the state of Illinois establishes the first juvenile court system. And the focus was really on emphasizing rehabilitation, which is not something we do in the adult system. And also establishing a less formal setting for decision-making that was separate from the adult system. They also wanted to limit the consequences of juvenile misconduct, so reducing sentencing and things like that. And by 1925, almost every state had established some sort of juvenile court system. So in the 1950s and 60s, this process really becomes more formalized. So we start granting more protections to juveniles, things like right to counsel, right protection from self-incrimination. And then in the 80s and 90s, we start to see this shift back to criminalization. And if you think back, this is kind of the time at which the Central Park Five, we're using terms like super predators, this push to like save us from these children who are just out of control. And this is when we start to see harsher laws and sentencing. More recently, though, in the last several decades, we started to shift back to more of that focus on rehabilitation. So we're recognizing more and more that juveniles differ from adults in very legally relevant ways. I think part of that comes from more research that's been conducted on adolescent brain development, things like executive functioning, all of that, I think, has played into this idea that maybe we overreacted, and so now we're sort of self-correcting.
If I might add a little bit to the formalization process in the 50s and 60s, it kind of sounds good. And I mean, I think overall it was probably good that they were trying to do that due process and everything. But it did, in hindsight, it's kind of looked at as having the unintended effect of making the system the juveniles were going through more adversarial. Like it was establishing like, okay, you're the person on this side. You're like now the one against the juvenile, sort of, but not really. You know, it was a lot of like kind of vagueness there, but it made it more like a trial rather than a informal rehabilitative process for kids. So while it's good that we started having laws on the books, those laws were kind of making the whole thing more criminal in the end. And I think we're still feeling some of the repercussions of that and how to kind of move forward from there.
So we're not going to spend a ton of time talking about these cases, but we're going to spend time talking about Kent v. US because I think that's probably the most relevant for waiver evaluations. But Kent v. US was a Supreme Court case in 1966 that involved a 16-year-old juvenile offender who had been waived to adult court and then that challenged that transfer on the grounds that he wasn't provided adequate due process. And so basically what had happened is he'd been waived to adult court without a hearing. I believe he didn't have an attorney and he didn't have access to any of the records that the court had considered when making the determination to waive him. So this case really helped establish this criteria that courts use when determining whether a youth should be waived. And I think Jason will talk about more about those criteria in a second. Just to kind of go through some of these other ones quickly, 1967 in Regalt, this helped establish that due process that Jason was talking about. So it essentially constitutionalized the juvenile justice process. Again, that's sort of affording juveniles with the same rights. So right to an attorney, right to remain silent. Roper v. Simmons was a 2005 case that said executing minors is unconstitutional. 2010, Graham v. Florida said no life without parole unless it's a homicide. And then 2012, Miller v. Alabama, no mandatory life sentences without parole for juveniles.
Mm-hmm. So I think you're kind of starting to, you sort of see in these case laws, the shift that's sort of starting to happening. Like it was in the 90s, the whole sort of strong criminality. And now slowly we've had different cases being like, no, like juveniles are different. Maybe we need to treat them differently. Like we can't, some of this stuff just maybe shouldn't apply almost by rule. And we're still working on where that line is, of course, but that's sort of the era we're in now. So as I said, these are the, you'll sometimes these referred to as the Kent factors. I have severely, reduced these. It's not as if the case law just says nature of offense, but this is just trust me, it's a reasonable reduction of the basic factors outlined in the Kent case. And so you can see it wants a court, remember this is for the court, this isn't necessarily for an evaluator to look at. This is what the judge should consider. The seriousness of the alleged offense. Was the offense violent and willful versus like impulsive? Was a person hurt, or was it just property damage? Were there adult associates in the same offense? Which, to be honest, I'm not entirely certain how they even meant that to be applied in terms of like, was that perhaps you could argue if there were adult associates, they just strung the child along, or they were adult associates, which is evidence that the child was like an adult too. I think there's a lot of different ways that can go. You'll hear a lot about that. The prosecutorial merit, i.e., is this a crime that, would be tried in adult court, assuming it was relevant for adult court? I actually see this in a lot of the reports that I get, is a part of the argument that I'll just say the other side for now, I'll go into more detail, will make is that the prosecutors agreed that they would try this case. That if we bump this up and waive this kid to adult court, then the prosecutors will go forward with this, as opposed to being like, don't waste our time. So that's something that can be considered. The maturity of the juvenile, you'll be hearing a lot about maturity in this case, because the Kent decision did not define what they mean by that. It's just sort of the general, like, well, are they mature or not? You'll hear a lot about sophistication as well, which is even worse. Previous legal history of the juvenile, that one makes sense to me. Have you been through this process before? That's, warrants consideration that maybe we just need to bump you up to adult court. And then risk to the community and amenability to treatment if maintained in the juvenile court. So basically, is this person going to be a risk if they're in the juvenile court and only go through the juvenile court? And even if they do go through juvenile court, will they even benefit from anything that's given to them? Which to me is probably the most important aspect of this whole thing personally, but I'm saying that as a psychologist. But there's been some, studies out there looking at the various statutes throughout states. I obviously can't say that every statute in every state has applied the Kent factors, but it's pretty well established that most effectively do. It won't be literal. We'll show you some of the statutory language in Missouri and Oregon, I believe, since we're familiar with those. But some version of those concepts is pretty common, where states do transfer or certification or whatever you want to call it. But the three sort of broad categories that always seem to come up, even with changes in wording or et cetera, and that are arguably something that we as mental health professionals can say something about, in an expert sense, in testimony, is the potential risk for dangerous behavior, and if kept in juvenile court. In other words, risk, violence risk sex risk, any of those. We have things for that. The juvenile sophistication and maturity, while the definition of that is extremely vague and annoying, it's usually fair to say that it's something that, would be within the realm of a mental health professional to comment on in some capacity. And their amenability to treatment. That's something we do even outside the context of juvenile transfer, is can someone benefit from treatment? So I already think that I'm taking up too much time, so I'm going to try to go a little quicker, but we'll see. I promise nothing. So I'm going to talk a bit about what I do in Missouri. So I do work for the Center for Behavioral Medicine, but all of my juvenile work is actually done privately. So I am just as far as I'm concerned, a random private licensed psychologist. And I'm frequently hired by the Children's Defense Team, which is, the lawyers. So I'm essentially only hired by the defense attorneys. You can bet that comes up a lot in testimony. I always say that, if you want to hire me, juvenile office, you're welcome to, but they never do. So that's kind of how that is. And this is going to be different from, Molly's perspective. So in Missouri, the juvenile office is basically, think of them like the prosecutors for the juvenile court. That's not literally true, but for our intents and purposes, you can think of them like the prosecutors. They're the ones who have to have a case and make the argument that the youth should be certified. And what certified would mean is certified to adult court. So if a juvenile is certified, that means they're removed from the juvenile court and placed into adult court. The juvenile office will provide a report from a deputy juvenile officer. So you can just think, well, what they are doesn't really matter, but the point is they're from the prosecutor's office. They aren't necessarily a psychologist or a mental health professional per se. They're coming at this from the perspective of, I'm an employee of the juvenile office. I'm familiar with the juvenile court. I know what we have to provide. I know what our situation is. I know what the statute is. And so they provide their perspective in that capacity. So again, this is mostly just, I told you this is going to be really practical. I wanted to include this just to show you how I introduce myself in these kinds of, when I'm hired to do these types of evaluations. This is essentially the beginning of my type of report. Undersigned evaluator is retained by defense counsel. I just make really clear that that's who I am, where I'm coming from, and that my job is to provide considerations for potential interventions related to a juvenile certification hearing. So I do not provide an ultimate opinion. That's one thing here. I don't end my reports by saying, and therefore, in my opinion, this person should or should not be certified. I try to make very clear that the extent of my role is to speak on clinical factors that are relevant to this decision. And I'm frankly also making clear who hired me. That can affect where I'm getting my information from. There are things I can only control for so much. You do your best to be as neutral as possible, but we all know about biases that come from when you know who you're hired by. So I think it's very important to acknowledge that in these things. So here's the Missouri revised statutes. I'm not going to read every single one of these to you, of course, but I'd like to, you can essentially see the Kent factors in these. Number one, the seriousness of the offense makes sense. And then they kind of include the idea of risk in the seriousness of the offense and whether the protection of the community requires transfer to the court of general jurisdiction. So the question being is this person such a risk of engaging in this behavior that they need to go to an adult court rather than a presumably less restrictive juvenile facility of some kind. You already start to see some of the actual conflicts between a clinical way of thinking and a legal way of thinking here, because there is, they're effectively linking the idea of the seriousness of the offense is necessarily, correlated entirely with the person's risk for reoffending, basically, which we know isn't necessarily true. someone with a history of getting into school fights is probably at a much higher risk of continuing to get into fights than potentially someone who has no history of anything and, you know, in the wrong place, wrong time type situation, you know, it's legal stuff. But that just kind of shows you the angle they're coming at this from. We got viciousness, property. I wanted to point out number 4, because we have repetitive pattern of offenses indicating youth is beyond rehabilitation. Those are 2 aspects that come up a lot in these cases. You know, the repetitive nature, they're just talking about whether the offense is repetitive, as in, did they do this multiple times? They're not necessarily looking at, have you been found guilty before or arrested before? It's just, you know, how many fights have you gotten into until you got in trouble? And then rehabilitation is, of course, a concept that legally means a lot, but clinically might not. You know, they ask me, how long does someone need to be rehabilitated? And I'll say, well, there's information to talk about how, you know, benefiting from a program, but rehabilitated, that's not really a term we use a lot in our, you know, capacity. It's just whether they can benefit, whether their risk is reduced. So those are just some examples. Basically, I will receive a DJO report. The DJO answers all 10 of those items, and they do provide an ultimate opinion about whether the juvenile should be transferred. And as I'm saying, they're speaking as an employee. And so they are speaking as someone who is intimately familiar, at least arguably, with specifically what the juvenile court and the potential division of youth services, which is technically different, but in the juvenile system here, you can either go to juvenile court services or a division of youth services. And so they are familiar with both and speak from that perspective, whereas much of my perspective comes more from a high-end research type of way. So I have a few examples here, because I'm keeping track of time. I have a few examples that I wanted to point out just to give you an idea of essentially, you know, for me, because I'm always hired by the defense, almost sort of what I'm arguably up against. At least that's what the lawyers would like me to be. You know, they would like me to see a DJO's report and be like, Jason, what's wrong with this? Like, I mean, what are some things that we could argue that, you know, the court should know that's relevant here? So these are all quotes from actual DJO reports that I've received. So for this one, when they're addressing seriousness of the offense, they pretty much just straight up say, assault first degree is a very serious offense, and the community requires protection from individuals willing to commit this crime. And that's kind of the end of it. Like I said, they sort of, you know, necessarily attach the seriousness of the offense with the idea that they are going to continue to be at risk of doing that specific thing again, when we know that's not necessarily true. It could be, but it depends a lot on, you know, the juvenile's history, all sorts of other things. Do they actually have a pattern of behavior of doing this thing or not? And on that note, repetitive pattern indicating youth is beyond rehabilitation. The quote being, the current allegations are the first of this kind reported to the juvenile office. So they're saying this is the first time he's ever been legally in trouble for anything like this. And in this case, it was actually someone who had never been in legal trouble before. However, the investigation indicates a pattern of ongoing abuse perpetrated by the juvenile that occurred over a period of 3 to 5 years. This was a sex offense case. You know, the allegation is that the juvenile had been sexually abusing his younger sibling for a period of 3 to 5 years. And so they will bring that forth as an argument that this shows that the youth is beyond rehabilitation because, look, it's been going on for so long. Now, I'm not going to say that that's irrelevant, of course, but we also know from our own perspective on sex offenses and stuff that a more established risk factor is whether you've been like caught, you know, got punished and or got some sort of treatment and then did it again. Like, that's a big red flag for sure in our field. Just the fact that you've done this to one person over a long period of time, certainly relevant in a legal sense. You know, no one's saying ignore that fact, but it doesn't necessarily relate to the idea that therefore you're beyond rehabilitation, especially if this person has never received treatment before. Sophistication and maturity, the best one. I hope I'm not going too fast, but I don't want to go over time. These are just some examples of what DJOs have said regarding the sophistication and maturity item. That the juvenile is well developed and mature appearing. So that was what they said in the sex offense case. Basically, they're just commenting, hey, he looks mature, you know, look at him. He's a big guy. It's pretty much the extent. They weren't really looking any further, and they were just saying that that's therefore worthy of consideration. Another one said the juvenile is of average intelligence. That's arguably more related, I'd say, but is average intelligence necessarily maturity or not? It could be an aspect of it for sure, but that's part of the argument again. And this last one's very good. Despite the limited knowledge of the juvenile's home and environmental situation, his emotional condition, and his pattern of living, the juvenile appears to be sophisticated and mature. So I forgot to comment earlier, but the statute says that the judge should consider the juvenile's sophistication and maturity as based upon his environmental situation, his emotional condition, and his pattern of living. So when you see the DJO report saying, even though we don't know a whole lot about the things we are literally required to know about, here's our opinion anyway. You know, so these are all kind of examples of where I often come in. You know, pointing these things out, helping the lawyers make this, at least this argument of it, even if I don't conclude anything myself. Youth's ability to benefit from programs. So I thought this was a good one as well. I spent a lot of time on this. The juvenile and his mother both reported he has had anger problems. His anger issues have never been treated. Therefore, his behaviors may require a significant amount of time to change. They were essentially suggesting, since he has never received treatment before, it will therefore take a lot longer this time. When arguably, if anything, the fact that he's never received any kind of treatment up to this point, hopefully that bodes well, that he'll actually benefit pretty well this time. You know, the research in general on this stuff is pretty clear. Adolescents can benefit from treatment quite effectively, especially when it's, you know, evidence-based, properly given, all that good stuff. And so this was something that I was able to argue, I guess we'll bring up in court and let the attorneys argue it, that like, hey, just because he's never been treated is, if anything, an indication that this is his chance to get better, like not an indication that we shouldn't do it just because he's never received it before. I'm going to spend a little more time on this one because it's a really big issue here. In Missouri, you can only be held in the juvenile system till you're 19, at least sort of. I'll get into that maybe, but that's like the legal statutory cutoff. And it can take a lot of time for the process to go. So if someone could commit an offense when they're 15, not even get to the point of having a hearing about this till they're 16, and then not get into the juvenile system properly until they're 17. And so then in the testimony, the juvenile office argues they'll only get at most a year and a half of proper treatment while there. That is not enough. And for the seriousness of the crime, that's not enough time. They should receive more punishment. And so they start making it about punishment. The fact that someone assaulted somebody and the juvenile people can only keep them till 19, they're looking at that as, so this person who stabbed someone maybe is only going to get a year and a half, you know, in jail as far as they're concerned. And that'll be something that they're trying to argue. And generally speaking, my side tries to argue that that's not the juvenile's fault, and that's not what we should be considering in this type of hearing. That being said, I've also talked to people who've been to the Division of Youth Services, to other juveniles, and they have not had good things to say about it. They basically said like, oh, there's no one there. There's not a lot of people who run stuff. They don't provide treatment very well. All these things, they're overburdened. And so that becomes something that the courts consider as well. I'd argue that that's the juvenile's fault. You shouldn't be putting them up to adult court just because you don't have enough stuff. But that is what comes up. Keep going. Oh yeah, racial disparity in certification. I don't have a lot to say on this one. This is just sort of an example of a statute that's well-meaning but doesn't really mean much practically. more often than not, this is all I see to that response. The deputy juvenile officer did not consider race when making this determination. Well, good. I'm glad that's what you did. That's what you did. It's not like I can say anything about it. No one's going to go in and evaluate if the DJO was being racist. You know, it's meant to be more of a broad statutory concept that, like, hey, let's look at the actual numbers. And some counties will actually show their numbers for certification, and I think that's pretty good. I think more counties need to do that, but more often than not, you just kind of see this. All right, the actual evaluation. So basically, I get hired by an attorney. I will have a clinical interview with the juvenile. The clinical interview is usually nothing terribly special compared to anything else we do in sort of like a typical mental health or psychological experience. You know, the juvenile's history, whatever it is they have, because, you know, if they're 15, then you've only lived so much life. But their history, you know, school, any employment they've had, mental health history, trauma history, medical history, substance use history, you know, and I'll talk about, you know, their relationship with their parents. You know, do you have a good relationship? How is your parents' parenting style? You know, just get their feeling on that. And then, of course, I'll also talk with at least one primary caregiver. Preferably, I'll be able to talk to many people. Occasionally, I'll have a situation in which there is a teacher who is actively saying, hi, talk to me. I really know this kid and I want to say something. And that's fantastic. More often than not, I don't have that, you know. I have school records perhaps, and so I'll get those, of course. But often the only people I have to talk to are caregivers who the other side will often make the argument are biased anyway, and therefore the court shouldn't listen to them. And why am I basing anything I have to say based on what they have to say? And that becomes a whole back and forth. And I'll also try to use a risk assessment when I can. And I'll talk a little more about the Savory in a minute. Well, because I'm definitely talking too much. So then there's the report. Pretty straightforward, sources of info, relevant background information, like I said, mental health, trauma, legal. I'll do an MSE, you know, just how are they now? A lot of lawyers feel that speaks to their current maturity. I don't make a lot of arguments myself about that, but if I say they were pleasant and cooperative with me, the lawyers sure ask me that every time I'm in testimony. So then there'll be the risk assessment portion of the report, and then I'll have a consideration and recommendations regarding intervention. Neuroscience studies talk about the research, evidence-based treatment for adolescents. What can we actually expect? Sort of remove from what is DYS, Division of Youth Services, technically able to do. And then a conclusion regarding all of that. So just a comment on the Savory. And Molly will actually talk about a few other things. But the Savory is one that I like to use a lot. It's, for those unfamiliar, it's a violence risk assessment, empirically supported risk and protective factors. They provide nice grounded ratings for each one. It's all sort of low, medium, high, and it gives you a specific description of like what those are. And not only is it very well established, it also includes a lot of stuff relevant to treatment amenability. Treatment amenability. And it kind of helps me seem very like fair, like I'm not just being biased. Because again, that's a problem when you're a private practitioner. That I'm like, hey, this is a standardized list of items, and here's how this kid, you know, does in all of these. There are other things that can be used. You know, the MMPIA is there for a sort of more general approach. PAI, I mean. I don't like to use a lot of broad personality measures because they are broad and kind of can bring up a lot of things that aren't necessarily relevant, but now will be used, you know, either unfairly for or against. The juvenile, I mean, just for example, you know, the MMPI has a lie scale. It's called the lie scale, right? Like it's, and if a juvenile like goes up on that, like that's just not going to look great. And maybe they're just trying to look good because they're in jail, you know, they're of course they're trying to make themselves look good right now. It doesn't necessarily mean that they are liars. Sector recidivism risk measures, I'll just comment that I actually don't use any of these. In my own, you know, webinars I've attended, education. I have a lot of concerns regarding them for use in court. Frankly, there's a very low recidivism rate for sex offenses in juveniles, and that makes the research very hard to do on that. I think authors of these reports should, of course, of these measures should keep trying to do this work, but for now, I don't use them. I just refer to the research. So then we get to the hearing. As in the testimony, fairly standard, prosecution and defense. A lot of arguments, again, justice versus treatment, real world versus ideal treatment. So that's what the OAS can do versus what I'm saying, which has to do with like multi-systemic family therapy, right? Is anyone actually giving multi-systemic family therapy? I can't say. And then, of course, the research versus the individual. So a lot of this fights between that. My last anecdote, and then I'll throw to Molly, is that I once got the question, because I said that there was some research to suggest that, with proper treatment, you can see benefit, even in this person's case, within a matter of months, like, maybe 9 months or something like that. That's what some empirical research was showing. And this kid had shot somebody, and so I got the question, so someone who shot someone can benefit from treatment in 9 months. So I'm guessing someone who graffitied can benefit from treatment in like 2 days, which is a nonsensical question, for something like this. Like, we're not treating the singular thing they did, it depends on the juvenile as a whole. But again, that kind of shows the situation you're in and trying to keep it clinical and being like, this is actually a different aspect I'm talking about here. Now I'll throw it to Molly now.
So in kind of preparing for this presentation, one of the things that Jason and I realized was that although there are some similarities, there are also a lot of differences in the way that our states conduct these evaluations. So the referral process is pretty similar. I'm hired by defense and the prosecution, I'd say probably an equal amount. In Oregon, the way that it works is the prosecution requests a waiver hearing in which they have to argue that the youth should be tried as an adult. And in Oregon, each side can hire an expert to conduct the evaluation. I think almost all of the cases I've been involved in, there's been an expert on both sides. So I want to touch base a little bit about Oregon law. Back in the 90s, the Measure 11 law passed, which basically said, this was kind of in that tough on crime era, basically required anyone 15 or older be tried as an adult if they're charged with a qualifying offense, and I'll show you what those are. It also included guidelines for mandatory minimums. And then in 1995, this expanded so that juveniles ages 12 to 14 who met specific criteria could also be waived. If you go to the next slide, Jason, it'll, I think, show kind of a graph of the charges that are Measure 11 charges and then the mandatory minimum sentences. You can kind of see what sorts of charges resulted in automatic waiver. Go ahead, Jason. So this is kind of how it's been in Oregon up until 2020. So basically up until this point, it was basically at the prosecutor's discretion. As you can imagine, there's a host of problems that result from that. But in 2019, Oregon passed Senate Bill 1008, which is a ballot measure that did a lot of great things for juveniles. It abolished life without parole for minors. It expanded early release, and it also restricted prosecution of children as adults. So part of what it did was it established a process for youth who had been convicted in the adult court system to have what's called a second look hearing that happens halfway through their sentence. And it's basically a process by which the judge determines whether the youth has taken responsibility for their crime or if they've been rehabilitated. It automatically placed youth who were accused of any crime into the juvenile system. So even if they'd committed one of those Measure 11s, they were automatically placed in the juvenile system. It allowed judges to release youth before they were transferred to an adult prison, as long as the youth had less than 2 years left on their sentence, and it eliminated life without parole for juveniles. So it did a lot of good stuff. So it also kind of created this process for waiver. So what it said was that the prosecution has to prove at this hearing that at the time of the alleged offense, the youth was of sufficient sophistication and maturity to appreciate the nature and quality of the conduct involved. So I know Jason has mentioned this term sophistication and maturity. I'm going to talk a little bit more about it. I'm going to preface it by saying I don't really know what that means. This is not a psychological construct. This is a legal construct that somehow psychologists have been called upon to answer this question of what sophistication and maturity is. But there's not a lot of guidance from statute or case law that tells us what that is. If you want to go to the next slide, Jason. So before I get into it, I want to touch on an Oregon Supreme Court case that sort of helped establish how we look at this. But essentially, it was a case that involved a 13-year-old who had participated in a murder and a robbery, and he had been waived because that Senate bill had not been passed yet. So what this court case said was that when looking at sophistication and maturity, we want to take a more, I guess, holistic approach to this. So we want to look at the child as a whole. Obviously, as you can imagine, youth will have some elements of sophistication and maturity that are adult-like, and some where they are average or below average. But essentially, what it helped sort of establish was that we're looking at mental or cognitive, social, and emotional capacities. And that's kind of what makes up this sophistication and maturity. Go ahead, Jason. So like I said, this is very unclear. The law in Oregon talks about this adult-like sophistication and maturity. And I think this is where a lot of evaluators and psychologists differ in how they look at adult-like. So what does adult-like mean? Well, if we're looking at the court system, we can assume that adult means 18 because that's the age at which a juvenile becomes an adult. If we're looking at it psychologically, most psychologists, I think, would agree that when we look at things like executive functioning, frontal lobe development, impulse control, all of that, we know that that does not just develop perfectly at age 18. We know that by age 25, 26, even to age 30, that is all still developing. So how are we approaching this? How do we look at this? The approach that I've taken, because there's not really any guidance, is I'm looking at this at age 18. That's when the law says a youth becomes an adult. And so what are the factors that we're considering? I think obviously cognitive functioning is a big one. So intellectually, where are they at? I think that's an easier one to sort of compare if we look at like average IQ versus above average superior. Social functioning. So like, how are they socially? Are they good at making friends? How do they deal with conflicts? You know, are they the type of person who explodes? They get upset really easily? Are they able to resolve conflicts with their friends in a mature sort of way? Same with emotional functioning. So like ability to regulate emotions, ability to understand emotions. Autonomy is also a big one. So, you know, physical autonomy, are they living at home or do they live elsewhere? How much do they rely on their caregivers for things like getting around? So do they have a car, a license? Do they work? So all of this kind of goes into that sophistication and maturity piece. Some states and some evaluators also consider physical maturity. As far as I'm aware, that's not something that's considered in Oregon, but it's basically like, are they big? Do they appear mature or are they underdeveloped for their age? Go ahead, Jason. So that's the first part of that revised statute. So looking at that sophistication and maturity piece, and, you know, I could probably talk about sophistication maturity for 5 days and still not have a great answer, but because of time, we're going to just sort of breeze through it. And then the other two areas that psychologists are tasked with determining are amenability to treatment and risk to the community. So the evaluation, the way that I kind of approach it is I always try to review the records prior to the evaluation. Sometimes that gives me a better sense. Like sometimes there's enough records where I can sort of look through and say, like, I don't think this kid is going to meet that sophistication prong. But typically we're looking at things like police reports, prior criminal records, school records, DHS records, if DHS is involved. And I typically will break the evaluation up into at least two sessions. The first one involves testing. I'll typically do some sort of IQ, adaptive if there's concerns about intellectual functioning, executive functioning testing, behavioral personality risk. In Oregon, because there's two evaluators, it's kind of created this process where the evaluators are really relying on each other. So if I know that the defense evaluator has already gone in and administered tests, I wouldn't want to go back and administer the same test. So it requires us to kind of communicate a lot and share the results. And it also requires you to place a lot of trust in that person. So sometimes the evaluator is someone I've never worked with or met. And so oftentimes they'll send like the raw scores or the protocol, and I'll kind of go through and make sure everything's kosher. But that's the first session. The second session then involves more of the interview process. And I think there's multiple approaches. Some take a structured approach, some take an unstructured approach. One thing to note about the way it works in Oregon is because I'm hired by the state a lot of the time, what ends up happening is that the defense attorney will sit in on the evaluation, and 9 times out of 10 will prevent me from speaking to the juvenile about the offense, which makes things really difficult because part of what I'm looking at is, did they have that sophistication and maturity at the time of the offense? And if I can't talk to them about the offense, it's hard to gauge what their thinking was at that time. So what it does is requires me to kind of look at all other areas of their functioning. Sometimes you can get a little bit from the police report, but I think it does create this disparity where you've got one expert who's been allowed to ask any questions they want. And then you have me who maybe is limited with the information that I have. And so each expert might have more or less information depending on which side retained them. So that can make things challenging.
Bit of an interesting, real quick. I actually, when I'm hired by the defense, and frequently asked, don't talk to them about the offense because they like don't want to do that. So even though I'm hired by the defense team, theoretically, they'd still almost prefer I just would be unable to talk about that on the testimony.
Yeah, and it totally makes sense, right? I can understand why a defense attorney would not want their client talking about the offense when we're not even at the point at which they're defending their client. Right. So it makes sense, but it does create some variability in the information that each side has. I want to spend the last few minutes talking about a measure that was created specifically for waiver evaluations. It's called the RSTI. It stands for the Risk Sophistication Treatment Inventory. It is a semi-structured interview that's used to assess the 3 things that we're meant to look at. So risk, sophistication, maturity, and treatment amenability. It provides T-scores, percentiles, and qualitative ranges. And as you can imagine, the courts love this tool because it takes something that is very sort of ambiguous and gray, and it turns it into something that's very sort of black and white. So I can understand why the courts like this. If you want to go to the next slide, Jason, I think there are some limitations to this measure. The sample size is pretty small and limited. It's based out of 3 states, primarily Black juveniles, and only a small percentage of the sample was actually being considered for waiver to adult court. So what I like about this measure is that it provides a lot of factors that are important to consider when looking at risk or amenability or sophistication and maturity. So I think it can be helpful. I think, reporting on the scores or talking about things very black and white has some limitations. And so there's been, I think, because this is a new process in Oregon, we're sort of figuring out how do we use this tool in a way that's helpful to the court without relying so much on those numbers or those scores. And also acknowledging that it's kind of the only tool that we have. And it does provide factors that are useful in determining things like sophistication and maturity. So I think, we had a very limited amount of time today. I think we could have spent a lot more time talking about these things. Hopefully we've provided you with enough information that you can go out and kind of search this stuff on your own and figure out if there's something you're interested in. But primarily what we wanted to convey was that juvenile transfer is a sort of ambiguous process that has, as you can imagine, major implications for justice-involved youth. But the interpretations of the criteria are ambiguous and depend a lot on jurisdiction. Psychologists can play a role in helping inform the court about relevant mental health and developmental aspects of transfer criteria. But like any forensic issue, I think as clinicians, we need to be really careful in how we approach these, the methods that we're using and the way that we convey that information.
And whether you want to give an ultimate opinion, because I like I said, I don't, but I have colleagues who do. They approach it just like the DJO did. They go through each one, all the 10, and provide a, here's my opinion. And no one has told them that that's wrong, So yeah, there's a lot to consider there. So yeah, thank you all for listening to us. Apologize if I particularly was talking maybe way too fast. I tend to do that. But yeah, we enjoyed it.
Well, I enjoyed it too. Thank you so much, Jason and Molly. I've seen a number of questions here. I'll also add, I don't think I've ever seen in any of these talks as you basically predicting what questions were going to come up. There are so many of these where somebody naturally had a question, and then about 2 minutes later, you answer exactly what they say, and them acknowledging, oh, that I've got it. Thank you. Yeah. So so bear with me as I filter through some of these.
Sure.
But a couple of people had some questions. As you brought up this issue of sophistication and maturity, and what that even means, how we assess this. Have you found there being particularly effective examples or effective ways of communicating maturity and sophistication to people in the court?
So I generally will kind of break it up into each of those factors we talked about. So like cognitive, social, emotional, and autonomy. And I kind of talk about how I think about those factors. I'll kind of look, the RSTI has also examines those factors. And so I can kind of use the RSTI to guide me. But it's kind of a free-for-all. It's basically kind of like, here's what emotional sophistication looks like. How does their emotional sophistication compare to, say an average 16-year-old, and how does it compare to an adult? Again, though, that, it's sort of flawed, right? Because it sounds sort of subjective, right? What may look like maturity to me might look like immaturity to somebody else. And I think my feeling is like, as long as I'm very clear about my own limitations and the fact that like this is very subjective, I do the best that I can, but I think of it as my job is sort of helping the court kind of parse out how to look at this type of stuff. I don't know if Jason, if you do it differently.
I'd say I do, if only because I, if anything, just kind of own really hard the fact that like I don't know what this means. I've said that in court on on testimony. I just said, like, to be honest, I don't really know what sophistication and maturity is supposed to mean in this context. And to which the lawyer went, yeah, like almost like accidentally just saying, like, everyone was like, yeah, we all kind of don't really know what this is supposed to mean. And I instead sort of shift it to, I didn't see anything particularly in my evaluation to suggest something like a developmental disability, right? Like that's arguably about, maturity in some capacity, sophistication. And then I will sort of reference the idea of, like, rather than all this constant comparison to other people, this is about an individual. And this person at the age of 16, no matter what they're doing in these other capacities, there's a lot of research to suggest that the way this person is now is very different in a lot of meaningful ways than how this person will be when they are 30, kind of making it about the fact that even if this 16-year-old is arguably pretty mature, even compared to some 20-year-olds or something like that, that this person's individual trajectory is, he's still an immature person. And that is the whole reasoning behind this, that adolescents at this stage of life are more amenable to treatment. This is an opportunity to do something about this, especially when they've never received treatment before in their lives. So I sort of shift it back to the treatment amenability aspect, because I would argue that it's frankly more important than this sort of vague concept.
Jason, in your response, you brought up that the idea that developmental disability could come up at some point in the evaluation. And we did have a couple of people that brought up, do you make changes to your evaluation approach, whether it's through testing or the types of questions you ask, when developmental disability might be a possibility or it comes up?
I would say absolutely I do. I don't know that I could give you a, specific way in which I change it. I really try to, and I do think this is effective in testimony as well. I try to approach this from an extremely clinical perspective rather than I'm doing a forensic legal thing here. The things I'm changing about the way I'm approaching this person aren't any different from if I was doing an intake for therapy, for example, and this person coming to me was clearly sort of like developmentally delayed. Like that might affect like the way I ask them about stuff. It might affect who else I really want to talk to regarding information they have, in terms of what questions I have for the caregivers, that type of thing. So it affects it in a lot of, I would say, almost sort of typical mental health approach type of ways. But I wouldn't say I do anything different in a legal consideration. I don't know, Molly, if you have different thoughts.
Yeah, I mean, I think if someone has a developmental disability, it's probably unlikely that I'm going to find them sophisticated and mature. I think, I'm not going to say that would never happen, but it's likely that like the emotional, the cognitive piece of things is not going to be your average 18-year-old. So I might conduct different testing to sort of get at that. But I think ultimately it's not really going to change my approach so much as my opinion about sophistication and maturity.
Yeah, it can be, I just quick anecdote, like, and kind of differences in our situations, because clearly since I was seeing this person, I was seeing someone who was 15, and he had clear developmental disabilities. He was clearly developmentally delayed. I mean, it was just, I don't know, just trust me, and he was 15. But since I was seeing him, it's because the juvenile office already did recommend that, yes, he should be sent up to adult court. And basically the reasoning for that, honestly, is that this is Missouri and it was a sex offense. That's what this stuff comes down to sometimes, So I was up there, I made all these kinds of arguments about he's clear developmentally delayed, this shows that, et cetera, blah, blah, blah. Even the victim's parents testified that, no, this guy is not an adult. We think he should be punished, but he's clearly not an adult. Look at him. But he was a big guy, probably could have played football. to be blunt, and they waved him up. And they said, yep, adult court for you. And I personally thought that was ridiculous, but that's this, what we're working in sometimes.
Certainly. I guess this question is probably geared more toward Molly, given it's about broadly speaking, several people had questions about, does your approach to the evaluation differ depending on if you're hired by the defense versus the prosecution? And several people had questions about, if you're hired by the prosecution, how much resistance you've had from the juvenile's attorney even allowing you to have face-to-face contact with them, and how that complicates the evaluation.
Yeah, so the law in Oregon essentially states, like, I, as the evaluator for the prosecution, have to be given access to all of the records. And part of that, I think, includes not just records, but access to the client as well. So I've never had an issue being allowed to, I guess, quote unquote, evaluate the client. It's more, I'm limited sometimes in what I'm allowed to ask about. So I've had it, it's kind of range. So like, I've had cases where, everything I ask the defense attorney is like, you can't ask that. You can't ask that. And in those cases, I've been very upfront with the prosecution of like, I am extremely limited in the information that I have, to the point where I don't think I have enough information to even answer these questions. I've also had it where, they've pretty much allowed me to ask anything, or they've allowed me to ask anything except specific details about the offense. And I think that's why that JC&V case was really important, because the idea behind it was, we're not just looking at the adolescent at the time of the offense. That's important, but we are also mainly looking at their sophistication and maturity in general. So I think I'm still able to answer the question as long as I have enough collateral data. So, part of that is trying to get, interviews with parents or teachers, school records, trying to get as much information as I can about how they were functioning at the time of the offense or around the time of the offense, without being able to ask them specifically about what happened. So it just sort of depends. Like I said, it's obviously much more limiting. I certainly understand why they would restrict those questions, but it does limit my ability to talk about the offense itself. And so I think that's part of why that JC&V case was so important. It kind of established how to, I guess, a workaround around that.
And if I might, as well, this is only kind of lightly related to actually what you were saying, but it did remind me, I think it's good to bring up a lot of the questions that, me or Molly could be receiving sort of, pressure on, or any of that kind of thing, or what's important, can actually be extremely different, if only because in Missouri, the youth system, et cetera, can only keep them until 19. But well, if I understood you right the other day, in Oregon, they can keep them till 25. So the crux issues like I was talking about of treatment ability, whether this 17-year-old can really benefit before they're kicked out of the DOIS system, doesn't even come up if you're seeing a 17-year-old in Oregon, because they'll be in there for 8 years or something, like no one's gonna hang their hat on that argument. But when it's a year or two, maybe it becomes a much bigger issue. And don't even get me started if they're gonna be 18 next month, so that can be a big difference in the eval types.
We had the question going on this line of treatment amenability, and kind of combining with this whole idea that you've both mentioned sometimes you are being instructed not to talk about the alleged offense. How difficult have you found it, or how have you gone about assessing potential treatment needs, let alone amenability, if you can't assess understanding of actions around the offense?
Yeah, that can be challenging. I can think of a case I did where the juvenile was accused of sexually assaulting the corpse of the person that he murdered. I was not allowed to talk to him about the allegations, nor did he claimed he couldn't really remember what happened conveniently. But, in looking at kind of treatment amenability in that case, well, we don't really have treatment for people who engage in necrophilia. Like that's just not a treatment that we have to offer. And so I think in that case, it's kind of easy to say like, look, this, regardless of where this person ends up, if it's into the juvenile system or the adult system, there's no treatment for them really. But I think sometimes it's much more clear, right? So and I think it also depends on the state. In Oregon, we have a pretty good juvenile system relative to other states where essentially anything you're going to get in the adult system, you're going to get in the juvenile system, if not more. So I think more often than not, what I end up seeing with these cases is you've got maybe a youth who is sophisticated and mature, but they're low risk and they're amenable to treatment. I think that's kind of what I typically end up with, is kind of a cluster that looks like that. And that's just because the juvenile system here we have access to a lot of resources. They're likely to get appropriate treatment in the juvenile system. I don't know how it is in Missouri, Jason, or if you want to speak to that.
I mean, I think that they do it. They really try to push the idea that anything about the person's mental state, et cetera, at the time of the offense is appropriate for sentencing mitigation, not for a juvenile transfer consideration. The juvenile transfer certification, whatever you want to call it, is more about how the person is as a whole, and regardless of how they were doing that day. The point is, I can evaluate for, this person again has a trauma history from really young and has a lot of clear behavioral issues since they were 5, for instance. And I'm not necessarily making a direct connection to, and therefore that's why they shot someone when they were 16 that one day, but I'm talking about what are treatable issues, what is something someone could get out of going to something like the Division of Youth Services, as opposed to adult prison, as I'll put it. And so the talk will be usually more about that it's like who this person is holistically, what have they experienced, what are some things that can be targeted. Sometimes doing almost what Molly mentioned of like, you don't have a specific treatment for this thing. Like I'll hear that a lot. There's no sex offender treatment specific in the youth services, but there is in adult prison. And that's a reason to push this, again, 15-year-old up into adult prison. And sometimes what I'm arguing is that actually there's not a lot of data to suggest that specific sex offender treatment for adolescents is substantially more effective than just other general evidence-based, treatments for adolescents. That you don't necessarily need it to be specific sex offender, or else, they won't benefit at all, So that's more what I will try to focus on, because they pretty much won't let me even in the hearing, like talk about anything about like, during that day, what was this person thinking? That's for a separate issue if they're even found guilty of it to begin with, which maybe they won't be. So that changes it all anyway.
And I think it brings up a good point too about like our role and kind of what is important to us as psychologists. So like for me, like I don't really care about sophistication and maturity, because that's not a psychological construct. And like what I'm most concerned about, I think, and what we should probably all be most concerned about is like, are they amenable to treatment? Like, to me, that feels like the most salient issue is like, can this person go to juvenile court, juvenile system and be rehabilitated and be amenable to treatment? And that's kind of at odds with like all the other things that we're supposed to look at. Like in my mind, someone who's sophisticated and mature, like that just means they're more amenable to treatment in my mind, right? But like the court doesn't see it that way all of the time. And so we're kind of at odds a little bit with what's important to the legal system. And I think what's important to us as psychologists.
One final question I'll have to wrap all of this up. We had one question here at the end about how do you address the need for years or services when, say, your client is 18, but the maximum age in the system is 19? Does that time pressure so impact what you communicate to the courts or impact your opinions?
So I'd say it does. It's certainly something I pretty much have to consider, because I know for a fact that it's going to be considered on, the juvenile office's side. That's half the time, that's half their argument. It's just that there's not enough time. And so I'll try to approach it, again, from sort of a research perspective, and acknowledging the limitations of that. That's part of what gets hashed out in the hearing of, like, ideal treatment versus what the Division of Youth Services can actually do can be very different. But I can't testify to what the Division of Youth Services can actually do. I can testify to their literature, and that they say that they provide evidence-based treatment, and so I'll say that, and then present research on, like, hey, like, for instance, here's this systemic review of several different, from these authors, considered like evidence-based, interventions for, reducing violence risk. And they all showed, effective treatment outcomes within the span of, this many months, that many months, et cetera, yada, yada. And so I'll try to talk about it just from a general perspective of, like, undoubtedly only having a year is not ideal. Like, no question. Like, I'm not about to argue it's not, that it'd be better if there was more time. But I can at least bring up, if it's true, which it often is for these things, what is available, and that, like, there are methods here, like, things exist. And arguably, I don't make this argument, but that's essentially the implication that the lawyers will then take more blatantly. Arguably, it's not the juvenile who should be punished just because the services the juvenile system is providing are inadequate compared to what they could be doing. Just purely, for example, on that, I said it stops at 19 in Missouri, but technically speaking, they can actually petition to keep them until they're 21. But then they'll just argue in court, well, they don't have the bed space for that, though, so it probably won't happen. And then there's actually a whole dual jurisdiction program in which, if someone's still a danger in their opinion at the end of their juvenile treatment, they can be transferred to an adult probation system. And if they screw that up, then they could face adult consequences. Seems like a great idea to me. But again, that system's underfunded. There aren't enough people who actually do it, so it probably won't happen. So let's just put them in adult court anyway. That's kind of what happens as well sometimes.
Well, Jason and Molly, I can't thank you enough for a very thorough, practical, engaging presentation.
Right.
Yeah. So thank you so much for coming and sharing this. The questions still keep coming through, so you've clearly resonated with a lot of people.
We probably have the same questions ourselves. So
sometimes, yeah,
that's fair. Well, perhaps there can be a part two down the road. We would love to have you back. So thanks so much, and thank you for all of you that have stayed and attended this Law and Mental Health series. That is a wrap for this week. We look forward to seeing you next week. Until then, take care.
Thank you.
Bye, everybody.
Bye.
Bye.